3 new bills have been introduced in Parliament to replace Indian criminal laws, the Code of Criminal Procedure (CrPC), Indian Penal Code and the Indian Evidence Act. Parliament has already, in 1973, enacted the CrPC as it stands today. From time to time, Parliament has also amended sections of criminal law to enhance the rights of arrestees, the rights to get bail, the right to be protected in a police station, and the provisions related to crimes against women. The Bharatiya Nyaya Sanhita BNS bills that were introduced in Parliament in August 2023 have now been referred to a Parliamentary Joint Standing Committee, but they still retain 85 to 90% of the older provisions. How many of the changes are pro-people and deepen human rights for all? How many of the sections in the new bills are even more draconian? To completely shed the legacy of colonialism and a controlled police state, any government needs to engage with its own vision and version of justice and match it with 21st century internationally accepted norms of justice. It has to examine its own methodology of dealing with those who are quote-unquote guilty and has to examine the government's own equations with institutional agents who enforce the law. Is the police autonomous? Is the police independent? Is the CBI autonomous? Do they have integrity? Or are they tools and weapons in the hands of an existing government? First, some more background. The Indian Penal Code IPC, originally enacted in 1860, which was British times, has also been amended several times, especially regarding provisions and sections on crimes against women. The CrPC has been amended also very often to give rights to arrestees. And most importantly, it introduced victimology in 2009 after the famed hearing of the Supreme Court in the Best Bakery case. Victims and complainants were given the right to be present during a criminal trial and not leave matters entirely to the state. The Evidence Act too has been amended, expanded to develop an understanding of evidence that includes electronic evidence. No laws are frozen in time, and it is the voice of the people in a fledgling democracy like ours that consists of elected representatives of the people and are meant to be the voice of the people, do not concentrate powers into the hands of the executive, that is the ruling government, or its law enforcement agency, that is the police or the CBI. For example, it is the outrage against custodial torture and absence of police accountability that led to some of the amendments on the rights of arrestees. And similarly, it was the outrage at the outcome of criminal trial of the Gujarat carnage of 2002 that led to the victimology insertions in 2009. And it was the outrage against targeted violence against women, the Nirbhaya case of 2012, that led to the amendments on the crimes against women the following year, that is 2013. We will now try and examine how the changes now proposed are not necessarily pro-people, not necessarily pro-people reforms in any way, but in fact are more draconian, giving questionable powers to an already unaccountable police and state. For example, we'll examine how new provisions that reintroduce death penalty, terrorism and everyday criminal law affect the rights of persons to obtain bail, and the new provisions are even an infringement on the independence of the judiciary. Most critically, we'll ask why this government, while tom-tomming the new approach, the first time anti-colonial approach as is being claimed, is mum completely silent on another important colonial legislation that gives draconian powers to the police, the Indian Police Act. Our police do not behave like public servants, the bobby in England who helps the widow cross the street, but as a man or a woman with a lathi, a gun that uses force, to be used against our own people. I'm talking about the Police Act of 1861, which continues to govern most police forces in all Indian states, from Kanyakumari to Kashmir, from Rajasthan to Assam. In fact, The origin of this act is very interesting. It can be directly traced to the 1857 revolt. It was enacted 4 years after that in 1861, and it was the British colonial response to crush future rebellions and to ensure that no such rebellions take place in future. Why does no government repeal this law, the Police Act, and drastically alter Indian law enforcement's attitude towards policing? Presently, this 162-year-old law vests the entire supervision of the police in the hands of the political executive. There is no independent supervision, there is no autonomous complaint mechanism, and therefore it becomes a tool for suppressing dissent, for controlling opponents, for not for good policing, not for good investigation, not for prevention of crime, but simply to use force. Arguably, police brutality, custodial torture, extrajudicial encounters continue unabated because of how this legislation has systematically empowered the police force without holding it accountable for their own criminal actions. Increasingly, we put in our new laws, whether it is the UAPA, the amended UAPA, or any other law, provisions within the law that prevent prosecution of police officers if they have not followed due procedure. So we are protecting, in fact, within the laws, criminal acts by the police. And no government, not this government, no government before that, has amended the Police Act of 1867. Have the sedition provisions, as is being claimed by government, actually been quote-unquote removed from the BNS, the Bharatiya Nyaya Sanhita? Official statistics reveal, and this is from the NCRB, so they're official, shockingly, that among the 10,938 persons booked and charged under sedition, which is Section 124A of the Indian Penal Code, from 2010 onwards, 65% of those booked were under the Bharatiya Janata Party government post-May 2014. Now, with the possibility of having another section inserted in place of 124A, which is Section 150 of the BNS, though it's not called sedition, does the government not have a tool to subvert, subjugate and silence dissent? The Supreme Court has before it long pending petitions challenging the sedition law, which, like I mentioned, was 124A, is 124A of the IPC. It now seeks to refer deliberations on this section to a constitution bench. The Union government has been trying to delay these deliberations, and at the last hearings, in fact, the Advocate General R. Venkatramani told the court that given the fact that now the bill does not include, the BNS bill does not include the offence of sedition, though that case should not be heard. However, other senior counsel like Arvind Dattar and Kapil Sibal argued that it's just a new label, new wine in old bottles, and in fact is even more draconian. Let's read Section 124A of the IPC. Whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend into 3 years, to which fine may be added, or with just a fine. That's the existing Section 124A under the IPC, sedition. Now, Section 150 of the Bharatiya Nyaya Sanhita Bill, proposed change law, BNS, states, whoever purposely or unknowingly by words either spoken or written, similar, or signs, or by visible representation, or by electronic communication, or by use of financial means, that's a new addition, or otherwise excites or attempts to excite secession or armed rebellion or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life, or with imprisonment which may extend to 7 years, and shall also be liable to fine. Now, would the cases charged now under this section, defined as endangering the sovereignty, unity and integrity of India, be any different from the existing ones charged under sedition 124A? Has the apple really fallen that far from the tree? The definitions used in clause 150 of the proposed new law encompasses the criminalization of wide ranges of actions and behaviors, demonstrably making the law of sedition under a new name even more stringent. Without being called sedition, therefore, it's harsher. The clause includes, for example, by financial means, without giving any explanation of what comes under it, and has created, therefore, more ambiguity. It's unclear. Additionally, there is also no clarity on what the term subversive activity, quote unquote, is or means for this clause 150. The usage of this vague term has every potential to criminalize protest, difference of political opinion, or even intellectual debate. Without the safeguards that judicial pronouncements have so far created under the sedition section, one can only imagine how this can become a tool in the hands of any government. There is another concept which has been introduced, quote unquote, encouraging feelings of separatist activities. This is couched in such broad terms that could include a lot of political speech and literature, even if it does not lead to any violence against the state. Strangely enough, a year and a quarter ago, the same government, before the Supreme Court, had itself said that it was going to reconsider Section 124A of the Indian Penal Code. That was in May 2022. And the Supreme Court, in fact, has passed an order which is still in operation today, that Section 124A, which is sedition, will be kept in abeyance, will not be used by any law enforcement agency till the matter has been finally judicially settled by the Supreme Court. The Union government's stand in the court was that Section 124A is a colonial provision and which requires reconsideration and re-examination. And when the Supreme Court stated it, the government agreed and said that it would do so. Instead of doing that, the government has come up with Section 150 in the BNS. The Supreme Court had also said that the quote-unquote rigors of 124A IPC isn't in tune with the current social milieu and was intended for when the country was under a colonial regime. So is the same tool, the same agenda that the British used against the Indian people now being used by present regimes against the Indian people? For decades, successive governments, different political parties, have used India's colonial era draconian sedition law against students, journalists, intellectuals, social activists, writers, anyone who's critical of authority. Despite being victim of this provision during British rule, individuals who formed post-independence governments did not repeal it. They did not remove such a power from the police and the state and did not remove it from our statute books. That was bad enough. But now, the Union government has not only widened its own powers over citizens under the proposed laws, violating the sovereignty given to the people of India under the preamble of the Indian Constitution, but worse, already citizens are victims of a breakdown of the rule of law and snatching away of fundamental freedoms under existing outdated laws. Will the new bills, the Bharatiya Nyaya Sanhita, 3 bills introduced already, will they be steamrolled through Parliament without due debate, amendments, and a repeal of the most draconian sections? Will Indian criminal law now be used against Indian people themselves? The hallmark of an authoritarian police state.